You've reached FIT TV. Stick around, we'll be right back. Seemingly, while the ink was not yet dry on the July of 2010 no-fault divorce bill, under the radar went a less popular, less understood bill that could put contention back in the family law picture that no-fault was attempting to remove. This new maintenance bill on its face can complicate matters for families in transition. I have with me to discuss this Rachel Green, who's a mediator and a collaborative attorney, and we'll get through going through the maintenance bill in its current form and talk a little bit about the history and why it's important. Hello, Rachel.
Hi, Chris. Thanks for having me.
You're welcome. Okay, so let's fill the audience in a little bit on the history of maintenance, if you will, before we get into the guidelines of the new bill.
Okay. Well, maintenance is what is commonly known as alimony. And in New York, maintenance has been called rehabilitative maintenance. So it was stated in the statute, which is still in effect, that the purpose of spousal support is to rehabilitate each spouse or the non-working spouse so that he or she can be ready to become self-supporting. So in the old days, 30 years ago, 50 years ago, when you had the old paradigm of the stay-at-home mom, then when there was a divorce, the mom would get alimony for life, basically. Under New York law, that has been abolished. There's no presumption that there's going to be alimony for life, and instead it's supposed to be for some short term or some limited period of time until the wife can become, or the husband these days, sometimes it is the husband.
More often than it used to be.
Absolutely, can become self-supporting.
Mm-hmm.
What has been passed now is a new statute that has given us a formula for determining temporary maintenance, which we don't know exactly how this is going to be interpreted by the courts, what temporary maintenance means. But it's basically pre-divorce spousal support, and there is a formula for determining it. The law up to this point under rehabilitative maintenance has been highly discretionary. It's not mandatory in any cases, and there are 14 factors that the judge would look at, and basically the 14 factors are all of the circumstances of the marriage. How long have they been married? What are their earning histories? What are their relative educations?
We're going to go over all those in a couple of minutes,
Exactly.
But the statute's clear on that. Go ahead.
So the end result was that you really couldn't predict with certainty what spousal support would be. And for permanent maintenance, post-divorce maintenance, we still can't, that statute is still in effect. We still can't predict with certainty. An anecdote I like to tell my clients in mediation is that a few years ago I went to a seminar on spousal support, and the teachers began by handing out a fact scenario. The couple's been married this long, these are their incomes, these are their assets, how much do you think spousal support should be? And everybody was supposed to sit down, and we had a room full of mediators who work in the divorce field. And the variation was astonishing. It was something like $2,000 a month for 2 years versus $25,000 a month for 10 years. Because this was a high-earning couple. But that's how much variety there was among practitioners applying this statute. And unfortunately, that kind of variation has existed with judges. Different counties have reputations for being giving more generous spousal support or less generous
As we
spousal
spoke about
support.
before the program, certain counties are higher, Nassau County's higher than Brooklyn, et cetera.
That's right.
So that goes on, yeah.
And in fact, in this statute, the legislature stated that they've had a situation where couples that have the same incomes will have very differing spousal support in different courts. And that gives people the feeling that it's not fair.
Mm-hmm.
The law should really be applied the same way to everybody.
That seems like that would have been a reasonable place to start, that many maintenance contracts were put in place and many divorces, but there wasn't any consistency, that the numbers were all over the place. So hard to, how did you get this maintenance, how did you get that maintenance? It becomes an unfair situation on the backside after the decision's over.
Right. And this is another reason why, if couples can work together in mediation, they can look at the reality and they can say, look, how much money do we have coming in? You're not earning that much money. What is it going to take for you to move from working part-time to working full-time? Or how long is it going to take you to finish your nursing degree and get a job? How much money comes in and what are your expenses? And we can really be realistic. I mean, anytime a couple separates from one home to two home, they're increasing their expenses, and there's always going to be some belt tightening that has to happen when there's a divorce. So the question is, how do you allocate the pain? In mediation, certainly, the couples who come in generally want to try to have a fair settlement, and we can look at it on the table so that nobody feels paranoid and feels like I'm cutting back, but he or she is not cutting back. And instead, in mediation, we put all the information on the table and try to be fair about it. And that's how we would resolve it in mediation.
You should write a bill as you just described it, because that sounds the most fair to me. But the way that this bill is spelled out, based on what I've seen so far, the criteria for which some of are understandable criteria, the rest of it is, how do you take such risks? Like the future of health insurance, no one really knows, but they want to identify what that's like. Or earnings capability, or earnings based on what someone will earn in the future. We're in a tentative market right now, business market. I don't know how anybody can identify these. Why don't we take the shot at going through some of the criteria in this bill, and let's see how many things we can handle. Okay? Criteria number 1 is the length of the marriage. These are criteria for establishing what a maintenance amount would be. Some of the criteria to make that decision. Length of the marriage.
So, I mean, the length of the marriage certainly affects spousal support, because it affects how much flexibility is there for change. If you've been married for 3 years, then you can kind of move forward as if the marriage didn't happen almost. Your career is not affected by the marriage. If you've been married for 30 years, that's different. You've grown to depend on the other person and on having your incomes and your futures aligned, and now that's going to be a big change. It's going to take longer to adjust to that.
Okay, and one of the more important criteria is the substantial differences in the income of the parties. That's the primary jumper, right?
Well,
that's the one
absolutely.
that makes everything go.
Absolutely. I mean, a few years ago, an attorney I know did a study. He had some law student interns working for him, and he had them pull every case in the prior 10 years to see who gets maintenance and when. So we found out that when the higher earning spouse makes 3 times or more than the other spouse, there was always maintenance. I mean, that was like one hard and fast situation where there would always be spousal support.
Mm-hmm.
But closer together amounts that they earned, it was, varied a lot.
That's not all that far away, the 1/3 from the 40%, 33% to 40%, not all that different from how the statute's going to look like.
Right. Well, the new statute, which again governs temporary maintenance, and we don't know exactly what temporary maintenance means.
I think it's like pendente lite.
It's right. Pendente lite means while the case is in progress. Right. So certainly I agree with you, Chris. If you are having a litigated case, which only 2% of people are having, then from the day the summons is filed with the court to the day that the judge signs the divorce judgment is going to be the period of temporary maintenance. That is clear. For the other 98% of couples who negotiate a settlement, and certainly in mediation, most of the time they're negotiating before a summons is filed, what is the period of temporary maintenance? I mean, one of the things that concerns me about this statute is that it says that the formula, which is very complicated, and I'm sure we're going to get into the details of that in a minute, that the formula must be computed. We must compute according to this formula what spousal support would be, whether there would be any spousal support.
Right.
And then we have to use these factors that we're going through and say why the factors would say it's not fair, it's not just and appropriate to have that spousal support. So they're saying to us there's a presumption that this formula will produce the right amount of spousal support. And at the same time, they're telling us this is just pre-divorce judgment spousal support. I mean, they're saying a lot of things that contradict each
Rachel,
other.
this is the easy part. It's going to get tougher. You ready?
Okay.
The next one's on top of what we just talked about. Standard of living of the parties established during the marriage. I find that in the child support, they used to use that language in the Child Support Standards Act. I found that difficult back then for most people to attain, especially if your income fluctuated. And during the marriage, you may have a high and a low. And maybe it's high and then drifting low. Maybe it's low and then drifting high.
Right. And again, certainly when you have someone who has their own business or whose income, they make commissions, so their income really fluctuates. They're not just your average W-2 employee. In mediation, we talk about what we're going to do. What are you going to do when you have a slow year? What are you going to do when you have a great year? And we're going to adjust. We're going to use reality.
Right.
If they've been married and living with those circumstances, they know that they're going to deal with those circumstances, and we're going to try to approximate the way they dealt with it during the marriage in the way they're going to deal with it in the divorce. But the standard of living during the marriage has always seemed to me like the most artificial standard, because they can never maintain the same standard after the divorce.
Yeah.
They're having a lowering of their
now
standard
you just have
of living.
to pay for a second house with less money. I don't know how that works.
That's right.
Okay, now the age and the health of the parties. Significant there, of course.
Well, that goes to their earning potential. Someone in their mid-30s who's been out of the workforce for 8 years is going to get back into the workforce more easily than somebody in their late 50s who's been out of the workforce for 20 years.
And if somebody is disabled at age 25, they can be a factor in terms of how far forward you want to take a contract.
Yes, and Chris, I should tell you that in the case of a disability that would prevent somebody from working, either mental or physical disability, the rules are different. And you are basically going to have lifetime spousal support. You're not going to be able to get out of that.
And that's always tricky for me. Lifetime for me is like, how do you get that far?
Right.
I mean, okay, 20 years, okay, 10 years. As soon as you get past a couple of years, I wonder how far in the future can you predict that person's situation?
What do our wedding vows say? Till death do us part. In sickness, that's right. In sickness and in health. Yep. In sickness and in health, until death do us part. And if somebody becomes disabled and then you leave them, you're kind of breaking the vows. So there's like some, bottom line value by the courts that you're going to keep taking care of that person.
Okay, let's go to the incurring education or training expenses. So somebody has a license, like a doctor or a lawyer or an accountant or some professional that has a license for his job. During the marriage is a factor in child support in terms of whether there's evaluating the license. Is that what this is referring to?
I think that's referring to someone who's going to school. So you have someone who said, it's been my dream to become a nurse. I'm gonna take go to nursing school. I'm gonna be in school for 2 more years, and I'll get my license. So then they're gonna get spousal support for that 2 years, and then it's gonna change when they graduate.
Okay, let's talk about the wasteful dissipation of marital property.
I think that one is there just so that the judges have a way to punish somebody who drains the bank account. The day the spouse. I just had a couple.
Remember the guy burned his house down in the city. Remember that?
that's
There's
pretty,
a nice wasteful dissipation.
That's right.
Of an
That's
asset.
pretty wasteful. I just had a couple who, the husband said he wanted a divorce, and the wife was really in shock. This came out of the blue, and so she went out and put $7,000 on their credit card that month. Now, what she did is she prepaid a lot of bills because she felt like she was afraid she was going to be
she did it on her own.
Homeless, but she did it on her home. So then you can imagine how upset and shocked he was when he got the bill. I mean, it's better to talk about these things before you do it. I always tell my mediation clients, don't move any assets around until we can talk about it.
Don't move the assets around is exactly what I say.
That's right.
Okay.
And certainly if someone had extenuating circumstances, a gambling disorder or, very lavish lifestyle with their new paramour, that's a way for the judge to punish them.
Could that be the transfer or encumbrance made in contemplation of a matrimonial action without fair consideration?
Yes, that's exactly what
Yeah.
that refers to as well.
How about the existence of duration of a premarital joint household, a pre-divorce separate household? I'm not sure that's easy to explain.
Yeah, I'm not sure
Let's blow that one.
right.
We're going to need some help with that one, I think. Act by one party against another, continue to inhibit a party's earning capacity.
So if one person is hurting the other one's career, certainly positive and negative contributions toward the career are going to be taken into account with determining spousal support.
That should be very interesting, that one. I mean, there's so many people do different things to slow people down or to hurt them.
Right. Well, I've had that one
process.
come up when we're talking about a license or degree earned during the marriage, and there's a presumption that the spouse has contributed. And I remember one couple I had he was an accountant, and he said, I was staying up late studying, and you were standing outside the room screaming at me that I'm never going to finish this degree, and I'm an idiot, and why am I trying to do it? And he said, what do you mean I have to give her part of my degree?
All right, let's go to another serious one, the availability and cost of medical insurance for the parties.
Well, medical insurance, we all know, has become a huge
How do you establish a statute now?
Expense. Nobody knows where it's going to go.
So this is one we could just toss to the wind right now, right?
But we can look at what it costs now. I mean, we can get estimates. How much a month is it?
I don't find it comfortable as a mediator trying to codify for the couple or trying to allow them to codify with the coverage on health insurance at this time, knowing so many things out in front of them are going to change.
Yes, that's certainly true. But what can we do with it? Nobody knows what's going to happen. I mean, again, what you can do is say,
I take responsibility for the
year.
decision I make.
Right.
I put in clauses like that. I'm
That's
saying
right.
review next year, review in 24 months,
right.
review in 12 months.
And often, somebody can stay covered under their spouse's health insurance for a while after they separate. And then, I hope that in a year or two there'll be better, subsidized health insurance for low earners.
But as to establishing a rock-hard amount, it's not realistic to say, we're just doing it because we have to do it.
And it's an unbelievable expense. Because $600-700 a month
it's a major
now.
hit.
Yeah, it really is.
Okay, children of stepchildren, disabled adult children of stepchildren, elderly parents, or those kinds of inhabitants that might be in the house.
Right, so they want to look at other support obligations that each parent might have.
Well, I'm glad they're looking at that because, previously to that, I wasn't sure that people were afraid to bring in too many different ancillary responsibilities in terms of financial responsibilities when we just had the child support issue to go over.
Right.
Well, I can't pay that amount because I'm already paying mom here $1,000 a month or whatever.
That's right.
And that's a factor.
Yeah.
It's a realistic factor.
Right. No, it's great that they're looking at who else is dependent on this person.
That's right.
And because that can also affect your ability to get back to work if you're providing full-time care for somebody.
Okay, the inability of one party to obtain meaningful employment due to the age or absence from the workforce. I guess that's often what we talked about before.
Mm-hmm.
Could happen. All right, the need to pay for exceptional additional expenses for the children. That's classes and schooling and daycare and medical treatment and stuff like that.
Or if a child has special needs and really needs some higher level, not average care.
Tax consequences. There's a goodie.
Tax consequences should always be figured out because you really want to see what are the dollars we're going to be left with. Also, spousal support, unlike child support, is deductible to the person who is paying it and taxable to the person who's receiving it. And there can actually be a tax benefit if the lower earning spouse is going to be in a lower tax bracket, then there's a net savings to the family by having some spousal support and transferring income to the lower earning parent.
That's what I do. I often suggest that if in lieu of a certain issue, if the income is going to drop too low by making it a child support, that they get a tax benefit on the maintenance side.
Right.
And
they can do that. If they're working in mediation and they're working on their own settlement, they can craft it any way that makes sense to both of them.
And in court, they may have a difficult time crafting that agreement if their lawyer wants them to do it another way or if the judge decides they want to.
Right. Well, there's opportunity for much more creativity and flexibility out of court than in court. In court, they are going to apply all these formulas for child support and for spousal support because the formulas are there and the legislature gave them to the courts and the courts are going to use them.
Right.
And sometimes they make sense and sometimes they don't. I mean, I've seen, even with child support calculations, I've seen times when we do the calculation and the amount seems just right, seems way too high or way too low. I've seen it all ways. It's not really a good cookie cutter formula, but it's better than nothing.
Yeah.
So it's great in mediation when we have a chance to look at the reality and say, does this make sense for you?
When I've modified from the percentages in child support, I haven't gotten any kickback. They've all sailed through the way I had put them in. I wonder if the same will be true in maintenance.
I wonder that as well. Unfortunately, recently in Brooklyn, the judges have been kicking back waivers of the Child Support Standards Act and saying that this child support is insufficient, and they've had to call a couple of couples back in to say, what are we going to do about this? Which I find actually slightly offensive. I mean, it's usually it's in a joint custody situation, because in mediation I have a lot of couples that in Brooklyn, we really have a lot of couples they're in agreement, and they have 50-50 time. So they're both feeding the kids, they're both housing the kids. You know, maybe one parent usually takes them for clothing. So then their agreement is how we're going to split clothing expenses, medical expenses, health insurance, you know, the expenses for the kids, but the basic living expenses both parents have. So it doesn't make sense for one parent to pay full child support. And they've come up with their own agreement. And then the judge is saying, sorry, I don't like this. I want you to pay full child support.
Right.
So it's very problematic. And I don't know whether we're going to have that with the spousal support as well.
What about the situation with children in regards to the next section? Next question would be to you. The reduced or lost earning capacity of the party seeking temporary maintenance is what this is all about, as a result of having foregone or delayed a career in education or an opportunity during the marriage. I always say to that situation, children are a choice. Of course, it doesn't stop me from applying a maintenance amount, but it's a choice that person made. I wonder if that other person needs to be penalized for that.
I guess that what the judges and the legislatures are trying to do here is take into account the reality that somebody who has been out of the workforce for a while is not ever going to achieve the same salary level that they would have had they continued working. And you're right, Chris, that there are choices that are made, and couples sometimes make the choice to have one parent home with the kids when they get home from school, have those preschool years at home or whatever it is, but they're making a choice that's going to affect their income potential for the rest of their lives.
And I should be looking at it that way to back myself up on the question, because it is an economic decision that we're talking about primarily here in terms of maintenance. And that person can't be, even though they chose to be the mother or they chose to be the father and the stay-at-home parent, would have to have some kind of response by the maintenance contract in that regard.
Well, and certainly in the cases where one parent is really a high earner, then it's not a problem. I mean, the problem happens for most middle class couples where there just isn't quite enough money for two families.
I got a good one for you. After all this is done, because we've finished off the review
factors
here on the maintenance factors, and then the last one says what they always seem to say: any other factor which the court shall expressly find to be just and proper, the court shall determine the duration of maintenance based on the length of the marriage and blah, 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 and other things. And it goes on to another list. But the just and proper is something we see all the time.
Well, that's because they always want to give the judge room for discretion for unusual circumstances. For example, somebody who has an inheritance and is really going to be independently wealthy for the rest of their lives. But if you just look at their earnings career and their earnings during the marriage and their education, they look like they need spousal support, but they don't really need spousal support.
And another thing that you had said in the communication to the New York State Council on Divorce Mediation was that we can never predict, this is your own quote, we can never predict with certainty how judges will interpret all of this. And will take a few years for us to probably figure all that out.
I think that's certainly true.
Yeah, I back you up there 100%. It seems like, I guess you're doing a lot of things here in this maintenance agreement. You have a lot of considerations, and you want to back yourself up because with that many things in play, there certainly is more room for error, I think.
Right, that's certainly true.
Yeah, we have to have some contemplation in that regard. What else could we say about maintenance that maybe we haven't said? Let's talk about the formula. We have another couple of minutes here to handle that. Okay, how I see it, It's fairly complicated. You want to try this, or shall I just read and then you
Let me try to give a summary, if I may.
go right?
First of all, this only kicks in when the lower earning spouse earns less than 60% of the higher earning spouse. Okay, so if one person makes, 100,000 and the other makes 70,000, then there's no spousal support. There has to be a somewhat substantial differential between the two spouses. And then what the legislature has us do is compare two numbers. And the first one is 30% of the higher earning spouse's income minus 20% of the lower earning spouse's income. That's one number. Mm-hmm. Or add them both together, both of their incomes together, and take 40% of that and subtract 100% of the lower person's income. And then you look at those two numbers, and whichever number is lower is the temporary spousal support for that case. Now again, we don't know how long temporary spousal support should last.
I took a couple of minutes to work this out with someone the other day, and it looks like it's a reasonable approach. The formula looks reasonable. I don't know how they came to that, but it's up to mathematicians, not myself, but it looks like a reasonable approach. But I see as you go up the ladder in earning income, like this could be a fairly big number to deal with.
It could indeed. I mean, I had a case that I was working on where I was shocked by the number when I did the calculations. And maybe that's partly because I'm in Brooklyn, where historically spousal support is low.
Yeah.
But the formula yielded a much higher amount of spousal support, and I was shocked, and I think the husband was also shocked. So this is what the court is saying is the presumption that spousal support, at least temporary spousal support, should be. Now, the statute explicitly says that this does not apply to post-divorce spousal support or to longer-term spousal support, and I don't know what that means.
I don't know, unless there's probably one already in place. It's the only thing I can think of. But to help the audience get a grip on what that formula looks like, I'm going to post up a formula that you'll see right after I speak before we close. Rachel, thank you very much. We ran out of time on this particular program. That was a great effort you made to describe something that could get very complicated.
You're very welcome, Chris. Thanks for the opportunity.
You're welcome. Societal and political trends are rapidly breaking down a family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every week. And of course, we always invite all opposing views. My name is Chris DiMaggio, and I thank you very much for watching FIT TV, and we'll see you again next week.